Question 5. I'm going to the Board of Directors meetings. I'm writing an email to management to address the statutory concerns. So before I go to the board, I'm going to set my format so that I get this 1 mark for having the correct presentation. So I'm doing question 5 and I'm going to say, to management at internetcars.co.za, so I can see that it's an email from I'm a manager at CTA auditors.co.za. If you didn't have all of the specifics because you didn't pick them up in the question, it's fine, but you have to show that it is an email. Subject, concerns with Companies Act compliance, date July 2020. Dear management, the following statutory concerns with regards to the Companies Act were identified. And I go to the question. They've only asked for Companies Act, so I can ignore my king concerns. And I'm looking at anything I made a note with regards to the Companies Act. So I can see here I've got potential reckless trading. I've also got lack of knowledge of the Companies Act. I've got non-compliance with the Companies Act, and the details for the non-compliance are up here. Shares were issued to a related party of a director. There wasn't a special resolution. I've got a concern with their conduct, and I've got non-compliance with Section 44, financial assistance for shares, and fair consideration. Alright, so I'm going to start with the first concern, which was the issue of the shares to a related party of a director, and no special resolution was obtained. So where am I going to find that? Section 41 of the Companies Act. Section 41, shareholder approval for the issuing of certain shares, says that the issue of shares must be approved by special resolution if the shares are issued to a director or person related to a director. Finishing Clark, person related. How do we know that she is related? Because she is his wife. So if you go to Section 2 of the Companies Act, the very first requirement to prove you're related is if you are married. So I'm going to say, per the Companies Act, the issue of shares to a person related to a director requires a special resolution passed by the shareholders. So I'm going to say shares were issued to Mrs. Carr, the wife of Mr. Carr, the marketing director, and no special resolution was passed. Therefore, non-compliance. I come back to the section to see what they state about any potential non-compliance, and they say a director can be held liable to the extent they were present and failed to vote against the issue. So it's important that I put that down now, because all directors were present and failed to vote against, so all can be held liable. So per the Companies Act, a director can be held liable if present and failed to vote against the issue to a director related. All directors were present and voted in favor. Therefore, all can be held liable for losses. So I've addressed the first issue. The next issue here is the reckless trading, because they issued to Mrs. Carr, so they didn't have to pass a special resolution because it was issued to a director. Section 22, reckless trading, says a company must not carry on its business recklessly with gross negligence with the intent to defraud any person or for fraudulent purposes. So they are trying to defraud the shareholders by saying it was an issue to somebody who is not a director, when in fact it was an issue ultimately to the director. Per the Companies Act, a company must not carry on with intent to defraud. The directors issued shares to a director's wife intending to defraud shareholders from thinking it was to someone other than a director. Therefore, we got non-compliance with the Companies Act. And as soon as I discuss reckless trading, I need to consider the director's conduct. Guys, normally we would then be discussing a reportable irregularity, but the question has limited me to Companies Act, so I'm not going to go there. So I'm just going to go to section 76, director's conduct. So 76, director's conduct, they must not use their position to gain advantage in their personal capacity or harm the company. More relevant though, probably in this case, is that they should act in good faith, in proper course, in the best interest of the company, with a degree of care and skill, which we can see they are not. So per the Companies Act, directors should act in good faith, in the best interest of the company, and with care and skill. So I can prove here by attempting to hide the issue of shares to a director, they are not acting in the best interest, and therefore I've got non-compliance. Section 77 then deals with the liability, and specifically because of these two sections of non-compliance. So liability, a director of a company can be held liable if, in accordance with the common practice or common law, they breach section 76 to 76.3 A and B, which is acting in the best interest of the entity. In addition, they can be held liable for damages if they carried on a business prohibited under section 22, reckless trading. So because I've now picked up the reckless trading and I've picked up their conduct lacking, I need to discuss that they can be held liable. So per the Companies Act, directors can be held liable for losses if they did not act in the best interest of the company and if they continued to trade recklessly. I've addressed the reckless trading. I've addressed the director's conduct. Next was the financial assistance for the issue of shares. Section 44. Section 44, you can give financial assistance. However, the board may authorize it, provided it's pursuant to an employee share scheme, which it is not, or a special resolution passed by the shareholders within the 2 previous years. This did not happen. And they must satisfy that afterwards they will meet the solvency and liquidity test. If you can remember, we said they were liquid and solvent at 31 May, so they do meet that. But the terms must be fair, and they are not. So, I need to prove non-compliance with this section, and then also state that if they were present and failed to vote against, they will be held liable for losses. So the shares were issued for 8 Rand when the closing share price is 11 Rand. Therefore, financial assistance for the purchase of these shares was given. So I prove that. Now, per the Companies Act, directors can authorize financial assistance for the purchase of shares, provided special resolution is passed by the shareholders within 2 years. So guys, all that means is that the shareholders have to authorize this decision, and ultimately their authorization lasts for about a period of 2 years. So if they authorize this in 2014, then this decision no longer is valid. They need to pass another shareholder resolution where they authorize the financial assistance. And then ultimately, the directors have 2 years from their shareholder resolution to go and authorize further and determine the terms and conditions. Plus, the conditions in the MOI must be adhered to. Plus, they must meet the solvency and liquidity test immediately after, and the terms must be fair. Okay, so what can I say? No special resolution was passed. The terms aren't fair, as they're R3 less than the closing rate. Do they meet the solvency and liquidity? I must go and test that. So I've got to go and do my current asset to current liability and total asset to total liability calculations to prove that, because if they don't, I've got a further non-compliance. So it's important to actually prove it in your workings. So they are solvent after, as total assets of 106470 exceed total liabilities of 103313, and they are liquid. After, as current assets of 91650 exceed current liabilities of 81980. But there's non-compliance as there's no special resolution, nor are the terms fair. Per the Companies Act, directors can be held liable if they were present and failed to vote against, so all directors were present and failed to vote against, therefore non-compliance. I've addressed that. Fair consideration, Section 40, consideration for shares. The board may issue authorized shares for adequate consideration as determined by the board. Per the Companies Act, the board should determine consideration for the issue of shares that is adequate for the company, issuing them at R3 less closing rate is not a fair consideration. And now I've addressed everything. So now I'm sitting at a place where there's potentially more I need to pick up. I don't know what it is. So now's a good time to open up your Companies Act contents page just to see if there's anything there that can trigger any additional concerns. Open up my Companies Act and I just go through. We've already identified things with related solvency and liquidity. We've addressed anything with regards to amending the MOI. They didn't mention the authorized share capital, so I can't go and discuss that potentially they exceed the authorized share capital. There were no pre-incorporation contracts. We've addressed reckless trading. Nothing really about the financials maybe being misleading. Authorization for shares we've addressed because there was specific shareholder approval required. Financial assistance for the subscriptions we've addressed. So there's no need to go and then address financial assistance to director because we've addressed it from the subscription of the shares. Okay, anything with regards to the shareholders? No. Anything with regards to directors? We've already discussed standards and conduct. Oh, and there above, there it is. Directors' personal financial interest. The issuing of shares to Mrs. Carr is a personal financial interest to Mr. Carr. So I go to section 75. Director's personal financial interest. Anybody who is related to a director is included. So this is the issue of shares to Mrs. Carr. What's the requirement? Director is supposed to disclose. Didn't happen before the meeting, so there was no need to disclose before. But at the meeting then must disclose his interest. It's obvious. It's about him. That's fine. We don't have to adhere to that. And any other information and pertinent sites doesn't have to disclose that. But if he's present, he must not take part in the consideration. And he does. He should leave, but he doesn't. So, I've got non-compliance with section 75. There was no discussion of it being ratified, and so I need to discuss the concern. Per the Companies Act, if a director has a personal financial interest, the director must disclose his interests, must disclose any other info, must leave the meeting and not vote on the consideration and not execute any documents. Mr. Carr did not leave the meeting and voted in favor of the issue of shares to Mrs. Carr, therefore non-compliance. Okay, let's go and have a look at the solution.